Welcome to Environmental Law Explored, a podcast series, the podcast of the American Bar Association section of Environment, Energy, and Resources.
This is the Forest Resources Committee podcast. I'm Andrew Keene, and I'm pleased to be co-hosting alongside Susan Jane Brown, Principal and Chief Legal Counsel of Silvix Resources. In this episode, we'll be talking about NEPA. Signed into law on January 1st, 1970 by President Richard Nixon, the National Environmental Policy Act is a cornerstone of environmental law. Today, going on 56 years old, it is experiencing foundational changes. Navigating the NEPA landscape in these uncertain times is no simple task, even for skilled and experienced practitioners, which is why it is our great fortune today that we are joined by two preeminently skilled and experienced NEPA practitioners who have kindly offered to share their insights and guidance. Dinah Bear is a former General Counsel for the Council on Environmental Quality, continues to work professionally in the NEPA field, and serves on the Board of Directors of Defenders of Wildlife. Ted Bolinger is also a former General Counsel of CEQ and an Associate Director of CEQ, and is now a partner at Perkins Coie, where he advises clients on renewable energy development, resource development, and transportation projects. Dinah and Ted, thank you for joining us. In the last few months, NEPA has been swept up in a whirlwind of transformation. In November, the D.C. Court of Appeals issued its decision in Marin Audubon, which, despite party presentment issues, held, arguably in dicta, that CEQ did not have rulemaking authority to promulgate the 2024 CEQ regulations. This decision was left undisturbed by the court's denial of a petition for rehearing at the end of January. Then, the North Dakota District Court held in early February in a challenge to the Biden 2024 regulations brought by 21 Republican states that those regulations were arbitrary, capricious, and ultra-vires, and vacated those regulations. That decision resurrected the CEQ regulations promulgated under the first Trump administration, which themselves are questionably lawful under the Marin County dicta and Iowa v. CEQ analysis. Indeed, on February 16, 2025, the day before we are recording this episode, we learned that OMB is now reviewing an interim final rule from CEQ titled Removal of National Environmental Policy Act Implementing Regulations. In the meantime, the Supreme Court is weighing further restrictions, or perhaps a broader ruling, on the reach of NEPA in 7 counties' infrastructure. Making things even more interesting, President Trump's January 20th, 2025 Unleashing American Energy Executive Order directed the current chairman of CEQ to provide new implementing guidelines for NEPA to expedite permitting for projects aligning with the administration's energy agenda. NEPA practitioners and their clients are living the old blessing, or curse, may you live in interesting times. Turning to our first set of questions, established by NEPA, the Council on Environmental Quality is charged with overseeing and guiding NEPA implementation across the federal government. Pursuant to an executive order from President Jimmy Carter, CEQ has been charged with issuing regulations to federal agencies governing the implementation of NEPA. In 1978, CEQ promulgated binding rules. These rules were largely untouched until the Trump and Biden presidencies, wherein they were amended significantly on 3 distinct occasions. All the while, CEQ's rulemaking authority went generally unchallenged. No longer. As noted in Marin Audubon, a 3-judge panel wrote that, though independent of the basis upon which the case was decided, regulations promulgated by CEQ are ultra-virus and unenforceable. On January 31st of this year, the D.C. Circuit Court denied a petition to hear Marin County en banc. Days later, Iowa v. CEQ was handed down, ruling that CEQ lacked the authority to promulgate its newest set of rules on the same grounds contemplated in Marin Audubon. So Dinah, our first question is for you. Given all of these changes, can you tell us in your view what the general status of NEPA regulations are today as we talk?
Well, I can tell you what they are today, which is not to be confused with tomorrow, or more likely Wednesday. But as of today, the regulations are what they were on June 30th of 2024, which is the 2020 regulations, plus, importantly, Part 1 of the regulations that were issued under the Biden administration. Clearly, that is not going to be a status of long duration, given the executive order that you mentioned. And as you already alluded to, OMB has signaled that they have an interim final rule pending, which, if they publish it according to the executive order's dictate, will be published on Wednesday. We'll see if they move it that fast, but they may. So if that is, and we haven't seen the details of that, I have been assuming that it is rescinding all of the regulatory authority, not just the current regulations. But again, we haven't read it, so I really shouldn't even be speculating on that. But I think there's a pretty good chance that is the case. What we do have is the statute, and we have a statute that has been amended fairly recently and fairly broadly in 2023 through the Fiscal Responsibility Act. Much of that is consistent with what is in the CEQ regulations. Some of it is not. There's also been other laws passed in the last 10, 12 years that, while they don't amend NEPA directly, amend the processes, particularly those that are subject to approval, an applicant's proposal, and subject to approval by a federal agency. So we have the Fast 41 Act that affected NEPA for a whole string of energy projects, transmission projects, aviation ports, waterways, set up the Federal Permitting Council, authorizes them to add new kinds of projects, which they've done, for example, for mining. We have the 2021 Bipartisan Infrastructure Act, which also has a number of provisions for NEPA that includes everything from AI to carbon capture, all kinds of activities. So when you put all of the changes in NEPA itself, and then the changes that are principally aimed at projects that are brought to federal agencies by applicants, there is a fair amount of statutory law. That said, it doesn't, with some exceptions, it doesn't go into the detail that the regulations do. As you know, the executive order that was issued by Trump directs CEQ to issue guidance to the agencies. We have not seen anything about that. We don't know if that's going to take the form of actual guidelines, or what it's going to look like. So we're just going to have to wait and see on that. I will say that, as you mentioned, there was an executive order in 1970, very early actually in 1970, and NEPA flourished for 8 years without regulations. CEQ issued 3 sets of guidelines during that period, and much of the foundational case law comes from that period. So NEPA is not going away. It's just presumably, as far as we understand it, the regulations, the CEQ regulations. There's also, of course, the agency regulations, which is going to be the subject, I'm sure, of much discussion, because we have 80-some agencies that have regulations which currently are required to conform to the CEQ regulations. Again, the executive order expressed some intent for unity, for a unified approach, but until we see whatever guidance is put out by CEQ, we don't know exactly how to interpret that.
Thank you very much. And Ted, to build off of that, how do you make sense of these cases? And what do you see as their most significant and immediate consequences, keeping in mind Trump's Unleashing American Energy executive order and also yesterday's interim final rule from the CEQ?
Just to clarify, what happened yesterday was the submission to the Office of Information and Regulatory Affairs of CEQ's interim final rule that would, we think, per the executive order on Unleashing American Energy, revoke the existing regulations. I mean, that's the command in Section 5 of the executive order is that CEQ propose rescinding CEQ's NEPA regulations, as well as also providing guidance to the agencies. But as Dinah said, the direction there was to propose that within 30 days of the executive order. So we'll expect to see that out on February 19th or maybe February 20th. And the interim final there will be, by nature of an interim final, they will have to have some finding of good cause and for waiting the usual notice and comment procedure. The ordinary course of notice of proposed rulemaking is before the agency takes final agency action, it asks for public comment. There's procedure for if the agency has a reason to waive that preceding public comment and say take public comment on an action that is final. It can do so based on exigencies such as an emergency action. I mean, a leading case here is requiring COVID vaccination for healthcare workers during the midst of the pandemic. And the Supreme Court, found that going through an interim final procedure, more or less, the question of whether APA had to be followed there was really cured by the fact that by the time you got to judicial review, the agency had actually taken public comment, responded to it, that sort of thing. So it's a procedure that allows the agency to move quickly, but still take public comment. An EO 12866 process is just interagency review. Per the executive order, people can come speak to the agency and OMB about what they think is in that interim final rulemaking. I would expect that interim final rulemaking is, very simply saying, well, the good cause here is President Carter's executive order 11991, which gave CEQ the authority to issue these regulations. That has been revoked by President Trump in Section 5 of the Unleashing American Energy and executive order. And therefore, the executive order basis for CEQ action no longer exists. It might also pick up the line of reasoning in the Marin Audubon Society case, and also as picked up by the North Dakota decision, Iowa versus CEQ, which proceeded to adopt the Marin Audubon line of reasoning that CEQ didn't have a specific grant of statutory authority to issue regulations, without giving a whole lot of credence to the position of the United States, which was based on other aspects of the statute and the broad mandate of CEQ in Title II of NEPA, as well as also the executive order basis to say that the CEQ regulations are valid. They've been part of the law. They've been more or less endorsed by Congress, used by Congress, incorporated by reference by Congress in multiple occasions, including in Title 41 of the FAST Act, as Dinah mentioned. And so there's a solid basis to say, CEQ does have proper authority. But, the North Dakota case more or less sort of adopted the Marin Audubon line of reasoning. That would be Judge Randolph's line of reasoning, which he's been espousing for quite some time now. Really, regardless of the fact that it's dicta in Marin Audubon, because that was a case that involved a categorical exclusion, a creature of Department of the Interior and FAA NEPA regulations, not the CEQ regulations. But, the North Dakota case also proceeded without any sort of reference to the President Trump's executive order. So it's really kind of odd how it seems to ignore that sort of foundational factor that the president had rescinded President Carter's executive order. I don't know what lasting significance these cases are going to have other than just as a basis for this interim final action, because, CEQ will receive comment on it, that it might draw a challenge for selecting an interim final rulemaking, but ultimately CEQ can, under the Little Sisters of the Poor versus Pennsylvania case in the Supreme Court, more or less sort of cure any procedural infirmities by simply responding to comment and finalizing their rulemaking, revoking the CEQ regulations, and reverting us back to, as Dinah noted, that period from 1970 to 1978 where most NEPA practice was pursuant to CEQ guidelines and agency NEPA procedures. Actually, at the risk of running on here, I just want to add to, the current state of play remains this sort of disconnect between the CEQ regulations, be it the 2020 regulations, 2020 is modified by phase 1, or 2020 is modified by phase 2, or rather the phase 2 rulemaking, which was set aside by North Dakota. We've got this disconnect at the CEQ level from all of the agency NEPA procedures that are basically creatures of the 1978 regulations. And so the Trump administration executive order kind of blows past any sort of further revisions to CEQ regulations, says, let's go straight to, the heart of the matter, and that is the updating of those 80 some odd sets of agency NEPA procedures that are out there, most of which incorporate the CEQ regulations in their entirety and make, agency-specific modifications. So that's a very significant, very weighty amount of rulemaking, both in terms of the number of agency NEPA procedures to be updated, as well as also just, their practical significance. I mean, it's the Trump administration's taking on a lot, but could fairly fundamentally affect NEPA practice as they are, for the first time, really interpreting the Fiscal Responsibility Act amendments to NEPA. Some potentially significant aspects, such as the definition of major federal action, adopted there, as applied to individual agency actions. It could be a very significant undertaking there.
So follow-up question on that, Ted, and I think that's a really good question and point that the CEQ regulations themselves are one thing, but then you do have other federal agency action or federal agencies NEPA procedures, which are vary depending on the federal agency involved. So the Forest Service's regulations are likely to look different than the Department of Defense's regulations, for example. And this is for either Ted or Dinah. Do you think the federal agencies have that rulemaking capacity to undertake an overhaul of their regulations? And how do you see that happening? That seems like, I think, as you referenced, Ted, a pretty heavy lift in terms of rulemaking, given other direction that is coming from this administration to do other pressing things.
Not to mention getting rid of a lot of federal employees.
Right. There's a brain drain at the agencies. And there are a lot of NEPA practitioners, in my experience, at the agencies to begin with. So who's going to do this work and how is it going to get done? And what's it going to mean for those agencies' mission critical work?
I'll offer that I think a lot depends on how specific the CEQ guidance is. I mean, if the CEQ guidance provides a roadmap, basically, if they were to say, okay, here's very detailed sort of model regulation, quote, guidance that, and I'm putting that in sort of air quotes because, at some point, if guidance is so specific, then it is going to beg the question, well, is CEQ really exercising rulemaking authority or violating what we affectionately know as OMB's good guidance on, seeking public comment on guidance. But if CEQ provides a reasonably specific roadmap, say, the 2020 regulations plus the Fiscal Responsibility Act aspects, which really were just sort of repeated in the 2024 regulations, not really interpreted much. But, say it had that sort of level of heft to it, that might make the agency's job a little faster and not reinventing the wheel so much. But on the other hand, we've all seen it has taken a long time for agencies to just do updates of their NEPA procedures based on, changes in statutory authority. And I've seen took the Department of the Navy years. I mean, it's like about 6 years to update their NEPA procedures just to incorporate 6 categorical exclusions. Now, Section 109 of the Fiscal Responsibility Act makes the adoption of other agencies' categorical exclusions that much easier, but you still got all the other aspects of it, and it's all got to go through interagency review. Section 5 of the executive order directs CEQ to convene an interagency group, a working group to coordinate the revision of agency-level implementing regulations for consistency. That doesn't mean literally conformity with NEPA, which was the standard under 1507.3 of the CEQ regs, but presumably they'd have some degree of coordination, and that sort of presupposes you've got a whole lot of pots coming up to boil more or less at the same time, because if you're going in series, how do you make sure that, the end of the series is consistent with the beginning of them? Ultimately, I think the answer to your question, Susan Jane, is just, well, where there's a will, there's a way. And if you've got certain officials, say at OMB and CEQ, saying that shall be done by X point in time, they can do something by that point in time. Query whether it can be done well by that point in time. Dinah, what do you think of that?
I agree with everything you said. I mean, it can be done. Obviously, the original regulations, the 78, 79 regulations were done fairly fast. But again, a lot of it depends on the time they give them. The only thing I would say is Ted mentioned the level of detail, a lot of it would depend on the level of detail and guidance, which is true. Time for everybody to look at the 1973 guidelines. They were actually pretty detailed and not challenged. They only dealt with EISs. One of the innovations of the regulations was that it started to deal with EAs and CEs. Also, I don't think, again, depending on what the guidance says, not everything necessarily has to be reinvented. All the agencies already have the 3 categories for EAs, CEs, EISs. The EAs and CEs are now recognized in the statute because of the FRA amendments. They weren't in the statute before. They were creatures of CEQ's regulations and case law. I don't know that they're going to have to redo all of those classifications, for example. They may for some things, but I'd be surprised if they had to redo all of the classifications. Yeah, I think, again, a lot of it to be repetitive, depends on the guidance. I do want to add one thing, and I apologize, but to go back to the first question on the case law, I just want to add one thing to what Ted said, and I agree with everything Ted said, although I do consider the Marin Audubon, Judge Randolph's Marin Audubon discussion dicta. But I haven't seen any mention of one thing that just really popped out at me at the Iowa v. CEQ decision. Not that, as Ted suggested, it may be just a historic artifact. But the one thing that really struck me in the opinion, other than, besides the kind of repeating and deferring to the discussion in Marin Audubon, was Judge Trainor's dismissal of the argument that it fell under the take care provision of the Constitution, because he said that, well, the CEQ, the Carter executive order, gave CEQ the power to create binding regulations affecting not only federal agencies, but all the third parties that are also subject to NEPA. Well, yes. There are no third parties that are subject to NEPA. Now, there are statutes that delegate the NEPA responsibility, a few in the world of HUD, Community Development Block Grants, and certain actions where tribes assume responsibility for NEPA. And there's answers to all that. I don't want to get too far down the road here because I don't think it's the major topic of the day. But the bottom line is NEPA applies to federal agencies. And I got the sense when I was rereading the Iowa decision that Judge Trainor really believed that NEPA applies to, I don't know who he believed it applied to, but maybe the applicants as well as the federal agencies.
Yeah, actually, if I could pick up on that, I think it's an excellent point. And, if you had, if for a different administration and a more greater likelihood of appeal there or successful appeal, we'd be having an interesting discussion about standing and ripeness and, really just why did the North Dakota District Court go a fundamentally different direction than, say, the Western District of Virginia and the Fourth Circuit in the Wild Virginia case. And here you had states that were arguing in some cases because they had delegated authority under provisions that say like the transportation law to actually implement NEPA, that they were directly
Statutory authority.
Yes, exactly. And that by virtue of, an MOU that they'd executed with the Department of Transportation, they were standing in the shoes of the Secretary of Transportation and therefore more directly affected by CEQ's rulemaking than others. And that, and also, special solicitude to the states gave them a basis for a complaint. Ultimately, I agree with Dinah. There's this perception that NEPA, directly regulates applicants, and that's not the case. And even where the state agency is standing in the shoes of the secretary, it's because they're going to receive federal funding and they're doing the NEPA work, necessary for purposes of obtaining federal funding. And so there's a government benefit and a price to be paid to obtain that, and that is, you inform the public. But with regard to, aspects of agency NEPA procedures that I think are the heavier lift, not the categorical solutions, they're pretty much on the books, EAs, they can always, the interesting aspect is going to be the adaptation of particular agency authorities and particularly threshold consideration. Having agencies say for the first time, here are the things that we do on a daily basis. Here are our authorities. for which NEPA does not apply. And to have that actually spelled out in their procedures, that could be a basis for litigation right there. To say NEPA does not apply to the following activities is very different from saying the following activities are categorically excluded because you've got, the out clause of extraordinary circumstances. It's not amenable to a facial challenge, or oftentimes that you'd have to have an as-applied challenge, whereas they'll have flat out agency authority, agency interpretation of their authority, and the application of NEPA spelled out in their regulations. So we should see a fair amount of litigation against these new agency NEPA procedures.
Well, and to make things even more complicated, we're also living in a post-Chevron world. And although the Council on Environmental Quality may be, or in the past may have been uniquely qualified to interpret NEPA, the statute, where does that leave the Department of Transportation or Fish and Wildlife Service or any other federal agency who might be interpreting the statute on their own? Because CEQ, again, it will depend perhaps on the quality and nature of the guidance that CEQ puts forward. But I tend to agree with Ted that now is perhaps a good time to be a lawyer.
Yeah, especially if you
Well,
don't have agency-specific, CEQ seal of approval.
Right.
Yeah. I mean, to be clear, the guidelines do get some deference from courts. And the regulations, of course, got substantial deference from the Supreme Court, many courts, 6 years prior to the Chevron decision. So it did not depend on Chevron. But I think you're absolutely right that for the other agencies, very hard to see how they get deference on interpretation of NEPA. So, yeah, depends on the quality and detail of the guidance from CEQ.
Well, and I think that sets us up well for our next questions. We're obviously living in a very uncertain time for NEPA practitioners, their clients, the public, regulated industry, tribes, and others who make use of the NEPA process. Ted, this question's first for you, and then we'll ask Dinah too. But what advice do you have for practitioners on counseling clients through these very turbulent times?
Yeah, it's a particularly problematic time for, say, like long lead time infrastructure development. To me, that things where you're looking to commit, significant resources at a point in time, based on, sort of, like say broadly, social license to operate. That we've actually gone through a full and fair environmental impact assessment. And there's a benefit to those sorts of projects to have the rules of the road more or less well established. And so it's fundamentally a problem of, sort of discerning, okay, so what are the clear hallmarks of a good NEPA process? How do we future-proof our project against possible changes? And of course, we probably haven't seen the last of permitting reform in Congress. That's another aspect of the President Trump's executive orders to direct not CEQ, but the National Economic Council and Office of Legislative Affairs to make recommendations on permitting reform to Congress. And that's, most likely sweeps broader than just NEPA, but NEPA, is oftentimes the cornerstone for all manner of permitting processes. At least that's the way it's used in Title 41 of the FAST Act. So back to your question, you have to, I think, be wary of legalistic arguments on why, you don't have to do NEPA for this project, or, well, here's a shortcut, and, we've got all sorts of freedom to run wild here. That actually, particularly for infrastructure projects that are going to have significant effects, that, if you've got not in my backyard concerns, because any infrastructure project worth its salt is going to be in somebody's backyard, to use the NEPA process to address that. Actually, interestingly, as Dinah and I were talking, she noted there's a fair amount of the public involvement procedures of the NEPA process, of CEQ's regulations. Well, they're not reflected in the Fiscal Responsibility Act amendments to NEPA. As there's a lot of public process that, and just sort of the basics of good scoping that are not spelled out in the statute, because Congress was very focused on deadlines and enforcement of deadlines and page limits and things like that got things moving, not so much the public involvement. side in the Fiscal Responsibility Act amendments.
Yeah, I think that's right on. So, Dinah, from your perspective, what do communities stand to lose the most from not only the changes we've been talking about, but also, frankly, the chaos that we've been talking about in the new landscape? What tools are available to best protect these communities from environmental degradation and exploitation?
Well, of course, NEPA is not the only environmental law, but I'm not going to address NEPA. It's a shame in a way this discussion isn't next week after we've presumably seen some guidance or guidelines from CEQ. But regardless of that, clearly there is going to be a lot of uncertainty and a lot of chaos for a while. There may be some opportunities there for communities, public interest groups, tribes, but I think it's going to take a while to kind of flush that out. As I said earlier, a lot of the fundamental NEPA case law is pre-regulatory NEPA. President Nixon's executive order is still on the books. It talks about guidelines directing public involvement. There is some reference to public involvement in the FRA statutes and some in some of the other amendments I mentioned, not to NEPA, but in particular areas. It's going to be more complicated, certainly for practitioners to put all that together, and everybody's going to be digging up not only old case law, but case law post-regulations that did not depend on the regulations. And there is some of that. I mean, I'm pretty familiar. I've spent 2 years of my life working on an amendment to one particular regulation and followed the case law on that. And there's case law that picks up the substance of that, but never actually references the regulation itself. Just talks about NEPA. So it is going to be, I think you said, a good time for lawyers in one sense. That doesn't mean it's going to be a good time, of course, for communities or tribes or public interest groups that really need action now. I'm not in despair over this. I think we do need to watch what happens to the statute very closely. I'm very concerned about any attempts to give CEQ statutory authority if the attempts at unity through a unified approach through guidance doesn't work well. I have seen some law firm blogs that have raised the question of, well, if they really want a unified approach, which our clients would prefer, why don't they stick with regulations? That's obviously not the first approach, but I certainly would not want to see a trade-off for CEQ statutory authority that gutted other important fundamental aspects of NEPA. So that is a concern of mine.
Thank you very much. And another question for you, Dinah, pivoting now. On December 10th of last year, the Supreme Court heard oral arguments in 7 counties' infrastructure, considering whether NEPA requires an agency to study environmental impacts beyond the proximate effects of the action over which the agency has regulatory authority. The anticipated ruling is likely to have extensive implications, including for agency authority to factor climate change into environmental impact analyses. What do you expect the court to do with this case, and how do you see this case interacting with these other issues that we've discussed so far?
Well, if, as all of us are saying, we can't foresee what the guidelines, CEQ's guidelines are, I'm certainly not going to be so foolish as to say I know what the Supreme Court is going to do. But I will just offer a few thoughts here. First of all, several briefs, obviously not the petitioners, but respondents, including the government at one point, and several other briefs, suggested to some people's amusement that maybe the court should simply dismiss the case as improvidently granted. Obviously, they haven't done that yet, but I'm raising that because it struck me in thinking about the recent developments writ large across the executive branch. That might be a more attractive option at the moment. We have a statute that has been amended since the EIS at issue was prepared and published. We have regulations that were in place that presumably are not going to be in place by the time they make their decision. We have an executive order that's been rescinded. And maybe most significantly, from a practical point of view, I suspect the Supreme Court is going to have a very crowded docket with cases that are of utmost significance to certainly the president and his administration, as well as obviously other parties. So whether or not they really want to take a case where, oh, and the other thing I meant to mention is that the arguments from the petitioners and the cert petition change between the cert petition and the briefings. So in the cert petition, much of the argument about why they should take the case was a split in the circuits. That argument was dropped in the brief, and instead they argued in the arguments that the Supreme Court should issue a rule that basically says agencies need not consider effects that are remote in time and space. So if they decide they have more important things to do, to put it bluntly, not that I don't think NEPA is critically important, that a case where the statute and the regulations and the cert petition are all somewhat irrelevant, some of them completely irrelevant now to the decision in the case, that might be one possible outcome. However, you certainly don't want to assume that. So listening to the arguments, both Ted and I were there. It's hard to predict, I think, certainly very hard to predict exactly how they're going to come out. It always is, but I think even more in this situation, perhaps. About the most I can say is that I think there was clearly some pushback against a hard and fast rule that would apply across the board. NEPA has always been interpreted significantly in light of the facts in a particular case. I would be surprised if they issued a black letter law that's just applied to every case no matter what. They do issue an opinion on the merits clearly, or pretty clearly, I think they'll be interpreting in light of DOT v. Public Citizens and the whole standard of what reasonably foreseeable means, which since the Surface Transportation Board EIS had issued in the case, the standard of reasonably foreseeable has been included in the statute in 4 different places in NEPA. So if they interpret that, that will be obviously important. I'm hoping that they restrain themselves from what I see as an unfortunate tendency to mix up tort law with NEPA law, but that is certainly a possibility. Other than that, I think we wait. We may wait a long time, given the docket that I think is going to be emerging pretty rapidly.
I thought it was interesting in the argument how petitioners' counsel, Paul Clement, was arguing for a new test and arguing basically to Justice Thomas, who is the author of DT v. Public Citizen. And he was asking for a test that, is both sort of his fashioning of proximate cause as applied to NEPA was geographic and temporal limits plus the limit of agency authority. And no need for the Surface Transportation Board to consider the downline effects of, a 9-fold increase in train traffic with, reasonably foreseeable consequences of carrying fossil fuel resources out of the Uinta Basin because their authority was limited to that 88 miles of track. And Justice Thomas didn't really even bite onto that. He asked Respondents' Counsel, can you tell me what their test is? Because I can't quite understand it. And a lot of batting around there about, do we really need a new test? I mean, Ketanji Jackson and Justice Jackson and Justice Kavanaugh, together, the 2 D.C. Circuit justices, asking, well, shouldn't we just be focused on deference to agency expertise? And so it'll be interesting to see how all that plays out. The Chief Justice was very interested in the import of the Fiscal Responsibility Act amendments, even to the point of suggesting that the page limit in the Fiscal Responsibility Act could act as a limitation on the scope of analysis. In other words, you wouldn't look at effects because you just didn't have enough words to cover it. I'm not sure that works. But there's some wild free thinking there. It's really difficult to see how they're gonna come out on this one. Although I tend to think that they'll probably come out somewhere, maybe not until the end of June.
Thank you both again. We've covered a lot of territory here today, and we have one final question for you both, which is, looking ahead, how do you see all of these different dynamics we've been discussing playing out over the next year, through the rest of this administration, and maybe even into the next decade?
It's an easy question. I'm sure you have a pat answer to this easy question.
I'm sure that I'll be listening to this 10 years from now saying, Ted, what were you thinking?
Famous last word. But what does your magic 8 ball tell you?
Future unclear.
Check back later.
Well, yes. I mean, it really, these are challenging times. My initial reaction was, well, yes, Trump administration will probably do a rerun of the 2020 regulations, plus, with some alignment with the Fiscal Responsibility Act. But that was on day one of a Trump administration transition, which has been much more, significant, much more ambitious than I had ever expected. I mean, as Trump 2.0 is very different from Trump 1.0. And having been at CEQ, being, the lead career lawyer at CEQ for the 2020 regulations, I kind of thought I knew where things were going, but I've been humbled in the past, three or so weeks, maybe 4. Yeah, we're coming up on 4 weeks now. It seems like a year. And so I would not underestimate the level of ambition that we will see in the CEQ guidance and the rulemakings, which I expect will proceed rapidly. And I think we're probably in for a good deal more tumult before hopefully things will settle down. I mean, I've heard many clients say, can we please not have the kind of pendulum swing that we've seen with, say, the definition of waters of the United States, is sort of the back and forth ping pong between administrations, because the great strength of the 1978 CEQ regulations is, yeah, they got a little stale, a little boring, they didn't keep up with the internet, or at least they didn't envision an internet age, but, and needed to have some modest update come, 2016. That was broadly recognized, but they were at least a solid cornerstone, well based on case law experience during the 1970s, and a fair articulation of that, and we're entitled to substantial deference, and I think we're all longing for that kind of regular order.
How about you, Dinah? Does your massive 8 ball say anything different in Ted's?
I could sit here and hypothesize both good and bad, disastrous and positive long-term outcomes, but it's just all speculation right now. We don't even know what tomorrow or Wednesday is going to bring. I do see the headline on my phone newsfeed right now is, Trump is making his first emergency appeal to the Supreme Court in this term. It's going to be a very busy court, I think. Yeah. I just think it's impossible to forecast the future right now, but many of us will be working to make it as positive as possible, and hopefully remember what NEPA is all about, which is not just a process, it's actually the environmental policies for the United States.
I think that's right. We're supposed to be fostering excellent agency action.
Yes.
And I'm with you. I hope the administration keeps their eye on that prize.
Yes. That would be nice.
But
If they've got many of the rest of us will be.
Yeah.
Yes.
An interesting aspect of the North Dakota case, after it got done with its main holding that CEQ had no authority, as a fallback, it went through the 2024 regulations and actually upheld them in some interesting ways, including the incorporation of climate change and environmental justice considerations as a reasonable exercise of policy authority under NEPA.
Yeah. I thought that was very interesting also.
So there's hope.
It also underscores how NEPA can be an instrument of administration policy. So, it by the same token can be an administration energy policy statute as well.
That's true. Which we can probably expect to see from this administration.
And Carter included actually in the 1978 regs.
That's right. That's right. Great. Andrew, do you want to take us out?
The last we have is just to say a thank you to Dinah and Ted for your time and expertise today. We really appreciate you.
Thank you for the opportunity.
Thank you very much. This is wonderful.
We hope you enjoyed today's episode. To learn more about our section, please visit our website at americanbar.org/enviro. Please check where you found us for future episodes. Thank you for listening.